Right. Good morning. This is CV 2026-027374 in the matter of Angela Flowers versus Darcy Myers and MR Capital. This is the time set for a status conference. Can I have each of you please state your names for the record, starting with the plaintiff, Ms. Flowers? Ms. Flowers, it looks like you're muted. Nope, still muted.
Is that better?
Yes.
Okay, Angela Flowers, plaintiff.
Thank you. Mr. Veeder, it looks like you're stating you can't hear us. But you can hear me, right, Ms. Flowers?
Yes.
Hello, can you hear me okay?
Yes, I can hear you now, counsel. Can you announce for the record,
Yeah,
please?
sorry. Devon Veeder on behalf of the defendants.
Great, thank you. All right, I've received the status report and reviewed it. Mr. Veeder, has there been any discussion between the parties since the filing of the request for the status conference?
No, but there was a lot of discussions prior to that. I did everything I could to get Angela to cooperate with us to get the loan paid off, but that we were at a standstill. So that's why we filed the document.
Okay. So, Ms. Flowers, how do things stand from your perspective?
Well, after our conference that we had, I did do a three-way conversation with Charlotte, who is Darcy's secretary, on that Monday, and they had told her that they would not accept payments because it was in foreclosure. And that is what your requirement was when we ended the conversation, was about the payments, to catch up on the payments, not about paying the house off. And so I did do a three-way conversation with Charlotte on that Monday after our meeting to try and get this situated, but they're not taking payments because it's in foreclosure. There is no sell date right now. There's not even a demand letter right now because the bank said that the lawyer had said that the bank doesn't really know how to file a demand letter because they don't really deal with like breach of contract for foreclosure for breach of contract. It's usually because the payments are behind.
Okay. So, I guess, do you have an idea of what you would like to do at this point going forward in regards to this risk of foreclosure on the home that's in dispute in this case?
Well, Mr. Veeder had called me and said about setting up a conference to talk to him, to do a three-way conversation with, I believe, his secretary and the bank. And I was okay with that. But however, I did not know that it was because he wanted to get it paid off. I thought it was just to talk to them about doing the payments. And so when I realized after I got off the phone with him that that's what it was, that's why I didn't take the phone call when she called me, is because I am not willing to give up the house without any kind of compensation or anything. And Mr. Veeder has made it very clear that Mr. Myers is not going to give me compensation for anything. And I don't think that it's right that he had breached his contract, that he was supposed to buy the house 5 years ago. And it took a lawsuit for him to say, okay, I'll buy the house now. After my credit's been damaged, after I've had problems with trying to get mortgages, trying to get car payments I get higher interest rates because of having this house on my credit. And that is why I sent 2 letters, Rule 408, I sent 2 settlement letters to Mr. Veeder to try and settle this out of court, and they have denied both letters.
Anything else that you would like to tell me right now, Ms. Flowers, before I hear from Mr. Veeder?
Well, I just think that if he wants the house, I should get some kind of compensation for it. I don't have a problem. I would like my house back. That is why I did the lawsuit to begin with. But I don't know if I'm going to win that lawsuit or not. And so if he wants the house, he can have it, but I want compensation. I'm not willing just to sign over the house with no compensation. And like I said, I don't think that it's right that he breached his contract and that I had to file a lawsuit for him to decide that he wanted to pay the house when he could have done this years ago when he was supposed to, and this would have been taken care of and it wouldn't have gotten this far. So like I said, I did send over 2 settlement things for him, and he denied both of them. And Mr. Veeder has made it very clear that he is not going to give me compensation for anything.
Okay. Anything else, Ms. Flowers, before I hear from Mr. Veeder?
No.
Thank you. Mr. Veeder?
Yeah, just to kind of clarify the record, MR Capital is the owner of the property. The property was signed over to MR Capital clear back at the beginning of the agreement, with the understanding that MR Capital would get the loan current, keep it in the name of Flowers, the loan in the name of Flowers until it gets paid off. And MR Capital did do those things. They made payments on time for years. The Flowers allowed that to happen. They agreed to extend the payoff date. And so when it got to a point where we could no longer make the monthly payments, Ms. Flowers brought this lawsuit. And I think it's important here, Your Honor, to know that the claim for breach of contract is for not paying off the house. So she sued MR Capital to not pay, when I say pay off the house, I mean pay off the loan. And so MR Capital is ready and willing to cure that by paying off the loan. She sued MR Capital. MR Capital saying, okay, let's do it. We're ready and willing to pay off the loan, but she's holding this hostage by not participating in the very thing that she sued for. So if this home goes into foreclosure and gets sold at auction, that's not going to help anybody. Ms. Flowers brought the preliminary injunction to keep the status quo. The status quo is to keep the house available. You know, if she wants to pursue some sort of rescission to get the house back, okay, fine, we can litigate that. Or if she wants to litigate for damages that caused because of credit issues, that's fine, we can litigate that. But we need to protect this house and get this loan paid off. So we're asking for an additional order that orders Ms. Flowers to cooperate with MR Capital to get the loan paid off so that we can keep the status quo.
Your Honor, can I just say something?
Well, yes, I'll come back to you, Ms. Flowers, don't worry. But I think I have some questions I want to ask Mr. Veeder first, okay?
Okay.
Okay. I think I have some concern here, Mr. Veeder, about it seems that you want your request for a status conference had asked the court to set the status conference and then to order the plaintiff to provide the bank authorization to accept payment from MR Capital. But from what I'm hearing, I don't think that the bank's going to do that because they're considering the mortgage to be in breach, given the special type of mortgage it was. And given that there's a possible breach issue here, we also have maybe a necessary party that needs to be added, in this case through the bank. And I don't know if that's through amendment of the complaint or through a cross claim by your client, but it seems to me that at this point, the bank might need to be involved in this case. What are your thoughts on that, Mr. Veeder?
Yeah, well, very possible, Your Honor. I think that there's one more step that we need to take before we really muddy up this case and bring in counterclaims and third-party complaints to the bank. We should try to just pay off the loan first. I mean, that's what Ms. Flowers sued for. If
No, it
Ms.
wasn't.
Flowers cooperate with the status quo and get this loan paid off, then there's no need to bring in a necessary party. That the house is secured, and Ms. Flowers can continue with her litigation. So, but if for some reason the bank says, yeah, even though Ms. Flowers is giving permission to go ahead and pay off this loan, we're not going to allow it because of some breach of the deed of trust, then okay, then let's amend, let's bring them in, let's do what's necessary. But it seems at this point the best path forward and easiest path forward is to get Ms. Flowers to jump on board. Let's get the loan paid off so that we can litigate her damages issue, which could include rescission. That's fine. We just need to protect the house first. So I'd ask that the court would give an order that orders Ms. Flowers to keep the status quo and participate in getting this loan paid off. And if that doesn't work, then we can amend and do what's necessary to protect the house.
Well, I'm short of, if the bank's not willing to take payment directly from your client, the other alternative would be what?
So you're saying if Ms. Flowers reaches out and says, hey, I'm okay with them paying off the loan, and they say, no, we're not going to allow it, we're saying, what would the next step be? Yeah, we would amend the answer and bring counterclaims against Ms. Flowers for breach of contract and specific performance to allow us to pay off the loan, which was what the original contract said. And then we would bring in M&T Bank as a necessary party to allow that process to happen. I haven't drafted it yet, Your Honor, so I can't lay out the exact claims, but I think that due process would require that they would be a named party if they're saying no. But I mean, the chances of them saying no, I don't want your money to pay this off is next to nil. It's just not there. And in fact, Your Honor, it's important to know that the general counsel for M&T Bank in their email said, we're not going to allow payments going forward. The remedy here is to pay off the loan. So they've already sent the signal that they're going to allow the loan to be paid off. They just won't allow payments going forward anymore.
Okay.
And Your Honor, if you feel uncomfortable with giving the order that we're asking for, we can file our own preliminary injunction requiring Ms. Flowers to participate in exercising the obligations of the contract to cooperate in paying off the loan. I mean, that's what she agreed to in the contract. That's what she sued for.
No, it's not.
Contractually, she should be doing that.
Okay.
It just seems like a waste of time to do that when we're already here talking about a preliminary injunction, keeping the status quo.
Okay. Anything else before I hear from Ms. Flowers, Mr. Veeder?
No, Your Honor.
Ms. Flowers?
Yes, Your Honor. I don't know where Mr. Veeder keeps saying that that we were allowing him to keep making the payments past the time that he was supposed to have paid off the loan. I have numerous emails and text messages asking him to please pay off this loan as early as 21-22 year. I have tons of messages to his secretary asking him to please tell Darcy to pay off this loan. I never authorized, I never said anything about that I was okay with him paying the mortgage past the time that he was supposed to take over the payments in May of 21. I never gave any kind of verbal authorization. I never gave any kind of written authorization. The agreement in the contract that we signed that was filed under false pretenses, because he had told me that he was going to pay off this loan within 2 years. If we were trying to buy a house, that he would pay off the loan in 2 years. If we were not trying to buy off the house, then the house would definitely be paid off by May of 2021. That was the agreement, and he did not follow the agreement. And I had started sending him messages when I was trying to look into buying another house about, can you please pay off this loan, because there's looking at debt to income ratio, and I'm not able to get another house because of the debt to income ratio. So I don't know where Mr. Veeder is getting the authorization, or whatever that you want to call it, that I said that I was okay with him to keep paying on the mortgage. Second of all, if you read my lawsuit is not for them to buy the house. My lawsuit is to try and get the house back, to have the title back in my name, because I got the letter from the bank, 2 letters from the bank, saying that that is the only way that we can stop the foreclosure, is if I get the title back in my name to match the mortgage, or if I pay off the loan. So my
But
whole
it sounds to me
my
that at this
whole
point, though, that they're telling you you're in breach of the mortgage contract.
Right, but they had told me that if I get the title back in my name, then the breach would go away, because the title and the mortgage match. I'm in breach of contract with them because I was not supposed to sell it to Mr. Myers the way that it happened. But I trusted him because he says he does this all the time and that he knows what he's doing. And so I trusted him that this was okay to do. I did not know that I would be in breach of contract by doing what I did. And the whole reason why the breach of contract came about was because Mr. Myers, back in February or March, tried to change the LLC to a different LLC. And that's how they found out that it was a business that owned it and not an owner house, that I didn't own it anymore. That's how the breach of contract started. And so my lawsuit was to try and get the house back, to try and get the title back in my name. Not what Mr. Veeder's saying is that I want it to be paid off. The only reason I'm agreeing to have it paid off now is because, Your Honor, I don't know if I'm going to be able to continue even with this lawsuit, because I'm not going to have the finances to do this. I don't
Yeah.
think I'm going to be able to I don't want to get really far into this where I'm going to be in debt with all kinds of fees and everything like that. So that is why I told them, fine, I'll do what you want me to do, let you buy the house, but I feel like I should be compensated for something. And Mr. Myers is not willing to give me any kind of money or anything. And I just think that it's a fair compromise that he gives me some kind of compensation for his breach of contract, for all the issues that I've had over the last, 5 years, 10 years, whatever. And I don't have a problem. I even am willing, if they don't want to take the payment from Mr. Capital, I'm even willing that if they want to put the money in my bank account, I will pay the bank. I don't have a problem doing that. I just want this done. I just want this resolved.
That last point you just made, you said you're willing to take the money and pay the bank. Are you talking about the payoff amount?
Yes, I will call and get the payoff amount and let them know what the payoff amount is. I believe last time I checked, it was, I believe 106,000, but I'm not 100% sure. But I'm willing to have them put the money in my bank account, and then I will send the money to M&T Bank if they don't want to take the money from Mr. Capital. But I feel like I should be compensated for something. And Your Honor, to be honest with you, I'd rather have the house go into foreclosure than for this to happen, because I don't think that Mr. Myers deserves to get the house after he breached the contract with me.
Well,
I mean, I know
here's
that
the
I know that's
problem
probably
with that.
wrong to say, but I just feel like he is really just trying to, he's not being fair, and I really feel like he's just trying to pull one over on me.
So let me say this, if in the circumstance that they give you the money and you pay off the house, then that's something that you two can agree with, can agree to. If you give authorization to the defendant to pay off directly, I think legally you're still in the same shoe. It's the same situation in terms of the legal issues in this case. They remain the same, whether they give you the money and you pay it off, or if they pay it off directly. But if the house gets foreclosed on and resold, then I don't think that there's any chance of the court ordering a rescission of the contract and ultimately being able to give the house back to you if I agree with your claims is going to be very difficult if the house is foreclosed on and sold to somebody else.
Right, I
So
understand that.
I think that that's probably the worst case scenario for everyone involved in this case, is if the house is foreclosed on and sold to someone else, because then now we're going to have another person saying that they rightfully bought the house from a foreclosure sale and that they're the owner, and then I won't have authority to give the house back to you or do much of anything that you want me to do. So let me ask you, Mr. Veeder. Miss Flowers had stated that she's willing to make the payment if you give her the money for the payment. Is that something you've discussed with your client? Are they comfortable doing that?
Yeah, I mean, it's a possible solution. I'm actually kind of surprised to hear Ms. Flowers say that when she was so adamant that she wasn't going to cooperate. It sounds like she's ready to cooperate, which I'm happy. Great. I think we should do this in maybe two steps. The first step would be that she just cooperate and let us pay it off directly, so we're not having to mess with opening up an escrow account. And I mean, that just could get messy. We're not going to just transfer money into her personal account and hope that she pays it. I would have to have it in some sort of a secure transaction. But if she would just cooperate with us to get it paid, it's the same thing. And then if that doesn't work for some reason, then we can work with Ms. Flowers to put the money in some sort of an escrow account in her name that then gets transferred to the bank. Yeah, that'd be fine. I don't think my client would have a problem with that. I would rather do it the most efficient way. So perhaps if Your Honor had an order saying that she would cooperate with these two steps, then that would suffice.
Miss Flowers, you have your hand up?
Yeah, Your Honor, I've never said that I wouldn't cooperate with them. I don't know why Mr. Veeder keeps saying that I'm not cooperating with them. He knows my stand. He knows that I don't have a problem with him paying off the house, but I feel I deserve some kind of compensation, and I'm not hearing that I'm going to get any kind of compensation. And like I said, I'm not going to have the money to probably go through this whole legal thing. That's why I'm just like, okay, fine, just buy the house and just, just some kind of compensation. And like I said, I've sent two letters to him saying that, if you give me this amount of money, and then I will.
Disconnected. Sorry, Miss Veeder. Sorry, Miss Flowers. Mr. Veeder's phone disconnected, so he can't hear what you're saying.
Okay.
Technology makes it, on one hand, easier so that you don't have to spend your time coming down to the courthouse for these types of things, but it makes it more difficult when we have these computer issues and someone can't hear what's going on. So it's a tough trade-off sometimes.
I apologize, Your Honor. I accidentally hung up on it.
Yeah, that the phone accidentally disconnected, and I was telling Miss Flowers that the trade-off in technology is it makes it easier that everyone doesn't have to come down to the courthouse for these short hearings, but the frustrating part is when we have computer issues like this, it's makes it a little bit difficult. But I think it's still better than having to have everyone come downtown for a 30-minute hearing, and especially with having to pay to park downtown and all the one-way streets. Yeah. But anyway, Ms. Flowers, you were saying that your concern is that you don't want to lose the ability to get some kind of compensation for for not being paid off when it was supposed to be paid off, and the subsequent damages you're saying have occurred to your credit.
Correct.
Okay.
And I'm not trying to not cooperate. It's just that the emails that I've got from Mr. Veeder about Mr. Myers is not going to pay any kind of compensation to me. And he's also telling me that I'm not going to get the deed back to the house because of how long it's been since, so the things that he has said to me, it's like, I just don't want to drag this out.
Sure. And what if I was to explain to you that if you gave authorization to the bank for the defendant to pay off the loan, you wouldn't be waiving your claims for reimbursement or to get the house back. You would still be able to present all of that to the court. And if you two couldn't reach an agreement, then either me or a jury would still be able to review that claim and grant it if either I or a jury agreed with you. Would that change your position on allowing them to make the payment directly? Because I think I agree that it would be logistically easier if they made the payment directly. But either way, either if they make the payment directly or if they give you the money and you pay, you're still going to be in the same position where you can continue to make a claim for reimbursement or to get the house back. In either case, you're not going to be waiving your ability to make those claims or to make those arguments or to get that relief.
Well, Mr. Veeder had sent me an email saying that if I want to try and get kind of reimbursements like that I'm going to have to hire an attorney and go through all of my finances and everything like that to get some kind of reimbursement. So obviously I don't have the money to get an attorney. That's why I'm doing this by myself. So that's one of the reasons why I'm not so just willing just to say, okay, I'll just give you the house and we'll just do the litigation and everything, because I'm not going to have an attorney to go through this with me. I have called multiple attorneys and all of them want $5,000 plus. I don't have that kind of money. I'm on Social Security disability. My husband's on Social Security disability. He's an amputee. It's just, I was hoping that Mr. Myers would just work out some kind of compensation with me, and we could just be done with this. I'm not going to have, like I said, I'm to the point where I'm ready to drop the lawsuit because I'm not going to have the money to do this, but I'm not just willing just to give up my house without any kind of compensation. So if he wants to give me some kind of compensation, I did send him a message, and the house is worth about $500,000. So he's got about $400,000 worth of equity in that house. And I had sent him a proposal for, and it's probably outrageous number, but I sent him a proposal for $300,000. And then I sent him one for $250,000, and he did not respond for either one of those. He said he denied both of those. So I know Mr. Veeder said that he wasn't going to give me any kind of compensation for anything. So why am I going to do the lawsuit and keep going for it to try and get compensation when I don't know if I'm going to get compensation? And I'm just going to sign over the house for him and continue with the lawsuit. And then, nothing comes out of it. And he gets the house and I get nothing. I just don't have the money to be doing a lawsuit. That's why when Mr. Veeder filed the motion for this, I did not file a motion back because I don't have the money to do this.
Yeah. Well, I think one thing to keep in mind is that if nothing else is done in this case currently, based on my understanding of the readings of the complaint and the answer, title has already been transferred to MR Capital. So they're currently the title holder. If nothing happens in this case, something's going to have to happen in this case. Some kind of court order or jury finding is going to have to occur for you to be the owner of this house, because currently you don't hold the title, they hold title. And so that's something that can be litigated in this case, like I told you earlier. But if the house is foreclosed on, I don't know what the result will be, but I know it's going to be a lot more messy and complicated and more difficult for you to try to handle representing yourself when there's another owner in this house now also fighting over proper title to the house.
Well, if it goes in the foreclosure, it's going to go on my credit report. And I mean, I'm not going to fight.
And it will also go
I'm
on
not
your
going
credit report. Yeah, you're correct about that.
Right. It'll go on my credit report, but I mean, the late payments are already on my credit report. So, but at least, I'm sorry, and maybe I'm sounding wrong or not sound, but I mean, I'd rather have it go into foreclosure than for Mr. Myers to get the house. Because at least if it goes into foreclosure, he has to bid on the house to get the house. Because then it goes into a trustee sale. So he would lose the house too. Not only would I lose the house, but he would lose the house too. So that is why I'm trying to compromise right now and say, you know what, just give me some kind of compensation and I will sign that. I don't have a problem giving you the house.
Yeah.
But I can't keep doing this litigation and stuff like that and go months down the road and have motions filed and everything like that. I can't afford all of that. So that's why I'm just trying to get it settled now. But Mr. Myers he doesn't want to give me any kind of compensation. I mean, even if he said, okay, you know what, I'll buy the house and stuff like that, I'll give you $100,000.
Yeah.
$75,000, something. I mean, just for him, to me, he's just being stubborn. He'd rather lose the house than give me any kind of compensation. When I'm saying that I'm willing to call the bank and get the payment settled and you can have the house. He just doesn't want to give me any kind of compensation. And Mr. Veeder has made that very clear to me. And he's also made it very clear to me that if we keep continuing with the lawsuit and I have to get a lawyer and stuff to go through everything and get like for the compensation, I don't have money to get a lawyer. I've tried to get a lawyer. I've been working on this since June trying to get a lawyer. I've called the state bar, Arizona State Bar. I've called legal aid. I've called so many people, and there's nobody out there that is working with me to make payments or anything. Everybody wants $5,000 plus in like an account, and then they take the money out of the account as they need. Honestly, Your Honor, I thought if I filed the lawsuit that Mr. Myers would say, oh, okay, I don't want to lose this house and stuff. I'll give you some kind of compensation and stuff like that to sign the house over to me. I really honestly didn't think that he was going to continue, doing this. I thought he would try and see the lawsuit and say, you know what, I don't want to lose the house. I'll give you some kind of compensation and stuff like that and be done with it.
Okay.
But I'm sorry,
So-
he's a very egotistical person
So let me ask,
with the emails and everything I've
if
gotten
you,
from him.
if you want to keep the status quo in this case and be able to move forward towards what you want, like I said, I think that the easiest path is to call the bank, allow MR Capital to make the payment, and then the house will remain as is. It'll remain in the status quo, and then you can make your arguments to the court about if you can't reach an agreement, what the appropriate amount of money you should get or get return of the house. That would be the easiest path. Is that something that you're willing to agree to call the bank and give authorization for them to make the direct payment?
I don't have a problem doing that, but I think that Mr. Myers should say, give me some kind of compensation today. I can do that today. I don't have a problem doing it today. But I think that Mr. Myers should give me some kind of compensation along with, either giving me the money to pay the house off or do, as Mr. Veeder said, put in an escrow. I don't know how that works.
But if they
I'm
don't
not
give you
a
if they
thief.
don't give you money for compensation to settle the case today, are you willing to call the bank to let MR Capital make the payment?
No, I'm not.
Okay. What about them setting up the account to send you the money and then you paying off the bank? Is that something you're willing to do
I don't
today?
have a problem with that. Yes, I don't have a problem
And that
with
would be
that, but I want
under the same
compensation. That is,
the same condition, though, that the issue of compensation would continue to be something that would be decided later on down the road.
but I'm not going to have the money to continue going with this lawsuit, especially if Mr. Veeder is telling me that he's not willing to give me any compensation. I don't know all the legal jargon. We can get into court and everything like that, and I'm going to get so confused about things. He knows how to word things and say things, and I don't know how to do that. I don't know all the legal jargon.
So unless you get some kind of compensation today, you're not agreeable to either calling the bank and allowing MR Capital to make the payment or accepting the payoff money from MR Capital and making the payment yourself. Is that what I'm hearing?
Correct.
Okay.
And I'm not trying to be stubborn. I'm not trying to be an unwilling participant or anything like that. But there was a breach of contract between me and Mr. Myers that he should have taken care of this 5 years ago. We would not be in the situation. And, things have happened with my credit. And I just think that he should just have to give me some kind of compensation if he wants the house. And we could have done this out of court. We didn't need to go to court to do this.
One thing Mr. Veeder had stated is that if the two options I just discussed with you aren't something you're willing to agree to, then they may file their own motion for a preliminary injunction or temporary restraining order, where then I order you to do one of these things. So that's something that they may do. You heard that?
Yes, sir.
Okay. All right, Mr. Veeder?
Yeah, thank you, Your Honor. Ms. Flowers, I think that just to clarify, I never said that MR Capital would never compensate for anything. The amounts that you were giving they were too high for in the moment to say, yeah, we'll give you that hundreds of thousands of dollars. What I'm hoping that you'll understand is that MR Capital needs to understand your damages. So if your credit was really hurt or damaged, let's put a dollar figure to that, and then we'll talk settlement. So we're totally willing to work and be reasonable with you on that. But my big thing is we need to protect the house. So before we get into those types of discussions, let's get this loan paid off. It's going to help everybody. So I'm really hoping that you're believing the judge. He is a judge. That these claims that you have for damages, they will live through us paying off the loan. We will continue going on with this case. I understand that your funds are low, but perhaps we can have an early mediation or something to get things resolved early so that you can afford this case, because it could get expensive if it goes forward, because there's need to be expert witnesses and things like that. So, but I'm just hoping, Angela, let's get this loan paid off. Your claims will be protected. We can talk settlement discussions after that. But I guess I'm pleading with you, Angela, to do this so that we don't have to incur more legal fees by filing our own preliminary injunction. And ultimately, I'm fairly certain the judge would sign an order ordering you to cooperate with this. Perhaps not, but I'm thinking he will. So I'm just hoping that you'll agree to do it now rather than wait for that. So that's all I have to say about that. Thank you, Your Honor.
And Ms. Flowers, when I nodded
Mr.
to what
Beater,
he was
I
saying, when I nodded to what he was saying, it was in respect to if this case continues on, there's mediation services offered through the court that you two can attend, and it's not a tier 1, so it wouldn't go to arbitration, but we do still have mediators that the court can send, ADR, alternative dispute resolution people that the court can send you to help mediate this. Another option is that there's sometimes other civil judges on the bench that are willing to do mediations that I could send you to, and then you'll hear from a different civil judge, not me, but a different civil judge who will help you to try to reach an agreement, and that's something that's not charged for. But go ahead, Ms. Flowers. There was something you were about to say.
Okay, so well, the doctor says, I say all this to you, that my clients are not going to pay out any amount close to what you're seeking. They may not agree to pay anything because of our strong defenses like latches, statute of limitations, acquaintances, etc. So, I mean, he sends me these emails and stuff like that kind of scares me, to be honest with you, because he's kind of being a bully to me. I mean, the things that he's sending me, it's I'll speak to my client about settlement, but the sooner you realize you're not getting the house back, the better negotiations will go. I mean, that's just things that, you don't say to somebody when they're trying to work with you and stuff like that. And, he's telling me this stuff, and it's kind of scaring me. And that's why I'm just trying to just settle this. But I don't know. I really honestly, I just don't know what to say. I don't know why. I don't even know why this is even in court and stuff like that. I don't know why Mr. Myers just doesn't say, hey, you know what, I'll give you this amount of money or whatever for messing up and not buying the house when I was supposed to and things like that. And, we could just be done with this.
Yeah.
I have too many medical issues and things like that. And the stress level right now is just, it's very high right now.
Yeah.
And so that's another reason why I'm willing my whole lawsuit was to try and get the house back, to have the title resend it back to me so that I could be the proper owner of the house. But I thought that I was going to be able to get a lawyer and everything like that to do this, but I can't do this by myself. I can't do this on my own. As you can see, Mr. Veeder knows how to talk legal and I don't. I don't, I'm just, I mean, this is just a messed up situation. I mean, like I said, if the house would have just been paid in May of 21, like it should have been, then none of this would be going on right now. And the only reason that I filed the lawsuit was because when I did talk to attorneys and they told me I was within the 6 years of the breach of contract and that I can try and get my title back to the house. That's why I filed the lawsuit, because I figured if he didn't want to buy it off and compensate me or anything like that, then I would try to get my house back, because then I would have all the equity and everything that's in my house.
Yeah. And they're going to come back and
And
say
my
they
payment
already
would be a lot
purchased.
lower than what I'm paying right now.
Right. And they're going to come back and tell me that they already purchased the house, and that's going to be something that either I or a jury would have to decide. But let me, we've gone 15 minutes past our time. I don't know if Mr. Veeder has another hearing or not to attend, but basically I think there's two. Let me say this, Mr. Veeder, I don't feel comfortable ordering Miss Flowers to call the bank and make the payment, call the bank and authorize your client to make the payment without you making your own motion for that, either through a temporary preliminary injunction or something to that effect. And I also think that if I am going to make that kind of ruling, the bank is an interested party here that needs to be added. So there's two paths forward here today, Miss Flowers. Well, I guess there's three paths forward. One of them would be to have reached an agreement during the hearing today to either allow the payment or to take the money and make the payment, which you've stated you're not willing to do, which is fine. You're allowed to make whatever positions you want, and the court's role is not to force you into doing something, force you into agreeing to doing something. Court can order you to do something, but it's not my role to force you into agreeing to do something. So that's path one. Path two is we leave this hearing and you two talk afterwards and see if there's something that you can work out. I encourage you to do that. But if
I'm
you
with
can't,
that.
path three sounds like Mr. Veeder will file his own preliminary injunction or request for a temporary restraining order. And then we'll be back here for another hearing in, I don't know, 2 weeks, talking about these same issues again and whether or not the court then, after hearing from the defendants through a proper petition and then possibly hearing from the bank, should order you to do one of these things to keep the status quo. But I'm not trying to force you to do one thing or another, Miss Flowers. Like I said, that's not my role, but I'll let you know. I suspect that if defendants have to bring a petition, they might make a request for attorney's fees. And I don't know if that's something I would grant or not, but it's just another thing to keep in mind that they might ask for.
Right. And that's stuff that I can't afford.
Right. So what we're going to do is I'm just going to
All I
direct.
request is does Mr. Veeder talks to his client about some kind of compensation today. And if Mr. Myers can give me some kind of number and say, okay, we'll deposit this into your bank or whatever, I don't have a problem calling the bank and getting the payoff and paying it. But
Okay.
Mr. Veeder's got to talk to his client about some kind of compensation that I would get so that we can just end this today and it would be done.
Okay. All right, Mr. Veeder, I think I've stated my idea of what the three paths are here going forward. I don't know what your client's position is on compensation to Miss Flowers. It sounds like she wants a lot. You're willing to offer some, but not that much. I encourage the parties to discuss this matter and see if you can come up with an agreement. But if you want an order from the court, I do have concerns that there will need to be a proper application. We'll have to get the bank involved. I'm hesitant to issue an order like that, given that the bank seems to me like an interested party that might have a say on what's going on in regards to some of the orders we've discussed.
That's fine, Your Honor. I plan on reaching out to the bank and seeing if they will allow us to make that payment on behalf of Ms. Flowers. And if that's a dead end, then we can amend and bring them in so they can have their due process met. But I believe that they're going to give authority to have us go ahead and pay directly. But either way, we'll lay that out in the preliminary injunction that we will be filing. If we can, I'm happy to work with Ms. Flowers again. I'll have a phone call with her after this, see if we can work something out. But if not, we'll pursue the preliminary injunction.
Okay. Okay. All right. Then the plan going forward from today then will be for the parties to further discuss this matter, see if you can come to an agreement on that. Otherwise, defendants may file their own separate request for a preliminary injunction, and then we also have the motion to dismiss. I believe I saw a response was filed. So there's a reply that will be due at some point, and the court will consider that in terms of the underlying complaint. I think that motion to dismiss is only as to the corporate party or to the non-corporate party. So the underlying case will still also have to proceed forward with, I don't think I've seen a scheduling order yet.
No,
So
not one yet.
I don't remember if I explained this to you, Ms. Flowers, but the next step for your complaint will be a scheduling order, which basically just says these are the deadlines for when we're going to exchange information. This is the deadline for when we're going to attend a mediation, things like that. Okay.
Okay, I have to do that I have to
Both
do
of
that?
you, both of you can.
because I don't
You
know
two-
what, I don't know what to do.
Yeah. I understand. It's a joint report that's given to the court. So, Mr. Veeder, you'll have to speak with Mr. Veeder
I'm just
about it,
going by
but
what Mr. Veeder does.
he'll know what the deadlines are. And typically it's very common for the parties to get an initial scheduling order set with the court. And then once you start getting into things, see that you might need more time on something and then to amend it. So the scheduling order is something that's required by rule, but it's not something that's written in stone. It can be amended to give the parties more time to do certain things if they need it. Okay. Any questions, Ms. Flowers, before we adjourn today?
Okay.
Any other questions, Ms. Flowers, before we
Yes,
adjourn
Honor.
today?
So if we settled at Mr. Meyer's station and I called the bank to pay off and everything like that, and they get the house, I get compensation, will the lawsuit just end? If they give me
Possibly.
compensation
Yeah,
and,
I mean, if you're
because there's no reason to continue if I give them the authorization for the house and I get compensation, then the lawsuit can just end.
yeah, if you two reach an agreement if you two reach an agreement where you're satisfied with the agreement, you're free to reach that agreement, provide a notice of settlement or a notice of dismissal to the court, and then that will be the end of the case. That would be the case so long as that is done before the defendants bring any kind of counter claims or cross claims. A counterclaim is a claim against you
Okay.
alleging something. A cross claim is a claim against the bank to bring them into the case alleging something.
Okay.
Okay. All right.
Well, hopefully
Mr.
we can get something settled.
I'll keep my fingers crossed for you. Mr. Veeder, anything else from your client's perspective before we adjourn today?
No, Your Honor. Thank you for your time.
Okay. All right. Well, thank you both for your appearances today. I hope you both have a good rest of your day. We'll adjourn at this time. Thank you.
Thank you.
Thank you, Your Honor. Have a good day.
Thank you, you too.